Hello legal minds, welcome to Law Tutorials. Today we're going to continue with lesson 1, Understanding the Law, part 2. Today we're going to be focusing on areas of the law. Now we have to understand that all legal systems deal with the same basic issues, but jurisdictions categorize and identify their legal topics in different ways. A common distinction is that between public law and private law. Public law is a term that is closely related to the state, including constitutional, administrative, and criminal law. And private law covers contract, tort, and property. Now, in civil law systems, contract and tort law fall under a general law of obligations, while trust law is dealt with under statutory regimes or international conventions. International, constitutional, and administrative law, criminal law, contract, tort, property law, and trust are regarded as the traditional core subject, although there are many further disciplines. International law refers to three things: public international law, private international law, also known as conflict of laws, and the law of supranational organizations. Public international law deals with the relationships between sovereign nations, that is, a relationship between countries. Now, the sources of public international law are customs, practice, and treaties between sovereign nations, such as the Geneva Conventions. Now, public international law can be formed by international organizations, such as the United Nations, the International Labour Organizations, the World Trade Organization, or the International Monetary Fund. Public international law has a special status as law because there is no international police force and court. For example, the International Court of Justice, as a primary UN judicial organ, lacks the capacity to penalize disobedience. Conflict of laws, also known as private international law in civil law countries, concerns which jurisdiction a legal dispute between private parties should be held in, and which jurisdiction's law should be applied to the dispute. Now, today, businesses are increasingly capable of shifting capital and labor supply chains across borders, as well as trading with overseas businesses, making the question of which country has jurisdiction even more pressing. The law of supranational organizations. Now let's look at the law of supranational organizations. The European Union law is the first and so far the only example of an internationally accepted legal system other than the United Nations and the World Trade Organizations. Given the trend of increasing global economic integration, many regional agreements, especially the African Union, seek to follow a similar model. In the European Union, sovereign nations have gathered their authority in a system of courts and the European Parliament. These institutions allow the ability to enforce legal norms both against or for member states and citizens in a manner which is not possible through public international law. As the European Court of Justice noted in its 1963 Van Gen and Loos decision, European Union law constitutes a new legal order of international law for the mutual social and economic benefit of the member states. Let's look at constitutional and administrative law. Constitutional and administrative law govern the affairs of the state. Constitutional law concerns both the relationships between the executive, the legislature, and the judiciary, and the human rights or civil liberties of individuals against the state. A constitution is simply those laws which constitute the body politic, from statute, case law, and convention. The fundamental constitutional principle inspired by John Locke holds that the individual can do anything except that which is forbidden by law, and the state may do nothing except that which is authorized by law. Administrative law, on the other hand, is the chief method for people to hold state bodies to account. People can sue an agency, local council, public service, or government ministry for judicial review of actions or decisions to ensure that they comply with the law and that the government entity observes required procedure. Let's look at criminal law. Criminal law, also known as penal law, pertains to crimes and punishment. It thus regulates the definition of and penalties for offences found to have a sufficiently deleterious social impact, but in itself makes no moral judgment on an offender, nor imposes restrictions on a society that physically prevent people from committing a crime in the first place. Now, investigating, apprehending, charging, and trying suspected offenders is regulated by the law of criminal procedure. The paradigm case of a crime lies in the proof beyond reasonable doubt that a person is guilty of two things. First, the accused must commit an act which is deemed by the society to be criminal. This is known as the actus reus, or the guilty act. Now, second, the accused must have the requisite malicious intent to commit the criminal act. This is also known as the mens rea, or the guilty mind. However, for so-called strict liability crimes, an actus reus is enough. That is, the physical element alone is enough. You don't need to prove the intention. Criminal systems of the civil law tradition distinguish between intention in the broad sense, dolus directus and dolus eventualis, and negligence. Criminal law offenses are viewed as offenses against not just individual victims, but the community as a whole. The state, usually with the help of the police, takes the lead in prosecution, which is why in common law countries, cases are cited as the people versus the name of the offender. Now let's look at contract law. Contract law concerns enforceable promises and can be summed up in the Latin phrase pacta sunt servanda, meaning agreement must be kept. In common law jurisdictions, three key elements to the creation of a contract are necessary: offer and acceptance, consideration, and the intention to create legal relations. Now, we should note here that there are other characteristics of a contract. These are just the most important and necessary characteristic of a contract. Now, tort and delict. Certain civil wrongs are grouped together as tort under common law systems and delict under civil law systems. This is to say that a wrongdoing under a common law system is known as a tort, while a wrongdoing under civil law system is known as a delict. To have acted tortiously, one must have breached a duty to another person or infringed some pre-existing legal rights. A simple example might be accidentally hitting someone with a cricket ball. Now, under the law of negligence, which is the most common form of tort, the injured party could potentially claim compensation for their injuries from the party responsible. The principles of negligence are illustrated by Donegal versus Stevenson. A friend of Mrs. Donegal ordered an opaque bottle of ginger beer intended for the consumption of Mrs. Donegal in a cafe in Paisley. Having consumed half of it, Mrs. Donegal poured the remainder into a tumbler. The decomposing remains of a snail floated out. She claimed to have suffered from shock, fell ill with gastroenteritis, and sued the manufacturer for carelessly allowing the drink to be contaminated. The House of Lords decided that the manufacturer was liable for Mrs. Donegal's illness. In fact, Lord Atkin took a very distinctively moral approach and said, the liability for negligence is no doubt based upon a general public sentiment of moral wrongdoing for which the offender must pay. The rule that you are to love your neighbor becomes in law, you must not injure your neighbor. And the lawyer's question, who is my neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. This became the basis for the four principles of negligence. 1. Mr. Stevenson owed Mrs. Donegal a duty of care to provide safe drinks. 2. He breached this duty of care. 3. The harm would not have occurred but for his breach. 4. His act was the proximate cause of Mrs. Donegal's harm. Now, torts can also involve intentional acts such as assault, battery, or trespass. A better known tort is defamation, which occurs, for example, when a person makes unsupportable allegations that damage another's reputation. We have two types of defamation, written and oral. Oral defamation is known as slander, while written defamation is known as libel. So people call it libel. Now, property law, on the other hand, governs ownership and possession. Real property is sometimes called real estate, refers to ownership of land and things attached to it. Personal property refers to everything else, movable objects such as computers, cars, jewelry, or intangible rights such as stocks and shares in companies. Now, a right in rem is a right to a specific piece of property, contrasted to a right in personam. A right in personam allows compensation for a loss, but not a particular thing back. Land law forms the basis for most kinds of property law and is the most complex. It concerns mortgages, rental agreement, licenses, covenant, easement, and the statutory systems for land registration. Regulations on the use of personal property fall under intellectual property law, company law, trust, and commercial law. An example of a basic case of most property law is Amory versus Delamere, 1722. A chimney sweep's boy found a jewel encrusted with precious stones. He took it to a goldsmith to have it valued. The goldsmith's apprentice looked at it, sneakily removed the stones, told the boy it was worth 3 halfpence, and that he would buy it. The boy said he would prefer the jewel back, so the apprentice gave it to him. But without the stones. The boy sued the goldsmith for his apprentice's attempt to cheat him. Lord Chief Justice Pratt ruled that even though the boy could not be said to own the jewel, he should be considered the rightful keeper. Hence, the principle of finders are keepers. Until the original owner is found. Finders are keepers simply means that if you find something somewhere, you pick up something somewhere, as far as the rightful owner is not known, the thing is automatically yours until the rightful owner is found. In fact, the apprentice and the boy both had a right of possession in the jewel, a technical concept meaning evidence that something could belong to someone. But the boy's possessory interest was considered better because it could be shown to be first in time. Possession may be 9/10 of the law, but not all. This case is used to support the view of property in common law jurisdictions, that a person who can show the best claim to a piece of property against any contesting party is the owner. Now, equity and trust. Equity is a body of rules that developed in England separately from the common law. The common law was administered by judges and barristers. The Lord Chancellor, on the other hand, as the King's keeper of conscience, could overrule the judge-made law if he thought it equitable to do so. This meant equity came to operate more through principles than rigid rules. For instance, whereas neither the common law nor civil law systems allow people to split the ownership from the control of one piece of property, equity allows this through an arrangement known as a trust. Trustees control property, whereas the beneficial or equitable ownership of trust property is held by people known as beneficiaries. Trustees owe duties to their beneficiaries to take good care of the entrusted property. A trust is a three-party fiduciary relationship in which the first party, known as the trustor or the settlor, transfers or settles a property, often but not necessarily a sum of money, upon the second party, the trustee, for the benefit of a third party, known as the beneficiary. A testamentary trust is created by a will and arises after the death of a settlor, while an inter vivos trust is created during the settlor's lifetime by a trust instrument. A trust may be revocable or irrevocable, depending on the instrument creating it. And this is the end of lesson 1 part 2. Thank you for watching. Like, comment, and share so that others can also watch and learn. Don't forget to subscribe to our YouTube channel and follow our Facebook page. And if you have any questions, inquiry, or any problem whatsoever, you can email us using legalminds115@gmail.com, and we are going to respond to you either with a video or with an email. Stay safe and take care. See you in the next lesson. Bye.